Good afternoon, everyone. I'm Tim Richards, Technical Services Manager of the Managing General Agents Association. And on behalf of the MGAA, I'd like to welcome you to our briefing this afternoon. This is being delivered by Clyde Co on the subject of strategic claims handling in fraud. Before I introduce our presenter, I'd just like to run through a few housekeeping points. Please ensure your microphone and camera are turned off. If you'd like to ask a question, feel free to use the chat button at the bottom of your screen. Time allowing, these will be asked and answered at the end of the event. If we run out of time, questions will be answered post-event. The presentation is accredited for CPD hours if relevant to your ongoing professional development programme. This briefing is being recorded, and a link to the recording will be issued post-event together with the slides and our feedback survey. Please take the time to complete our survey, which will take no longer than 2 minutes. This allows us to deliver the best possible future events to our membership. So once again, today's briefing is on the subject of strategic claims handling in fraud from Clyde Co. So let me introduce you to our presenter, Sarah Hill. Sarah is a partner in Clyde Co's Birmingham office and leads their fraud practice group. She is responsible for the strategic development of counter-fraud initiatives across all Clyde Co's business lines and for leading the department nationally. So without further ado, enjoy the briefing, everyone, and over to you, Sarah.
Thanks very much, Tim. Good afternoon, everybody. Thank you, first of all, for taking your time to join us this afternoon. Just before I move into the learning objectives for today, I wanted to share something with you which is personal to me, actually, and hopefully leads into the learning objectives and the understanding as to why fraud is so important to me. Many moons ago, I was a trainee, and I was a trainee in a high street practice. And I was within the civil department managing some RTA claims. And one particular claim, we were asked by the defendant insurers, could the claimant be interviewed in our presence? Now, this was a very legitimate law firm, and we had no issues with that at all. So we agreed. Claimant arrived, investigator arrived. Investigator, it was fine. The interview was fine. It was going swimmingly. At one point, the investigator turned to the claimant and said, but this isn't a genuine claim, is it? Because you're not the driver. You're not the claimant. It was a male driving the vehicle. And the claimant turned to me and she said, do I have to answer that question? At which point, the alarm bells were ringing and I knew this was a fraudulent claim and we could no longer act. But I think that demonstrates really that actually identifying fraud at an early stage within the claims handling process is just key. And so the learning objectives today, and here I am 20 plus years later, still doing this. So the learning objectives really is to look at strategies to detect fraud, the types of fraud that you may face on a day-to-day basis, summarise the investigative and intelligence strategies that can be used to defend cases, also explains fraud strategies and tactics and some of the things that we do, certainly within my department, and that might help you when you spot a fraud claim. And also then when you do have good evidence of fraud, what legal tools, remedies are available to you. So if we could move on, please, Gareth, to the next slide. So just feeding into that, so the agenda today is all about spotting fraud. And then once you have spotted it, how do we investigate it to maximise that opportunity to repudiate the claim for fraud? And then really looking at those tools, as I indicated, and what can happen following the initial investigation stage. If we could move on, please, Gareth. So what I've done today is grouped some of the fraud types that we see on a day in, day out basis, and I'm sure some of you will see as well. So apologies for those of you that are dealing with these types of fraud on a day in, day out basis, but I thought it would be useful just to summarise them again. So first of all, staged contrived incidents. So staged incidents are the types of cases that we see where the two parties are effectively in on it together. And you've probably seen reference to this in terms of induced accidents where somebody deliberately applies their brakes to cause an incident and in order to present a fraudulent claim. Contrived, on the other hand, these are cases that there's no incident at all. It's all made up on paper, it's fabricated, and in fact, the first fraud ring that I ever dealt with, again, many moons ago, involved a number of these cases where essentially the network, the individuals were just creating these cases on paper. The incidents never took place. If we could move on, please, Gareth. Fictitious losses, we see a lot of this. So this is where the incident may be genuine. Usually is genuine, but where a head of loss is fabricated in order to maximise the opportunity of the claim. So things like we see quite a lot in terms of if you've got an injury and they need some additional services, so special damages claims, so things like care, even, would you believe, dog walking services. So that the list can be quite long, but they're generally, this is where you need to consider the invoices that are presented and the types of losses that are presented and how that fits with the circumstance of the claim. And then finally, something that the industry is seeing as very prevalent at the moment. And in fact, our own data over the last 12 months indicates quite a rise, an increase in these types of cases. So we're tracking currently a 15.2% increase in exaggerated and layered claims that are coming through to us. And this is where, well, you'll all know what an exaggerated case is, but what is prolific at the moment is the maximising of the value of the claim, the layering. So we're particularly seeing it in well, it's across all product lines really, and that's the point I should make, is that these types of frauds do cross all product lines. But to give you an example in relation to exaggerated and layered cases, we often see this in the motor space, particularly following the whiplash reforms. We never used to see multi-site injuries, now we are. We never used to have whiplash claims with tinnitus claims tagged on, now we're seeing those. So you can see that actually the fraud types are similar in terms of the types of issues we're dealing with. And what will happen is fraudsters will land on a fraud type and maximise the opportunity. Okay, if we could move on, please, Gareth. So one of the things that's really important for us is to understand, when we're looking at identifying fraudulent activity, is actually what are we faced with. So we've already talked about the types of frauds that you might see and might spot, but who's controlling those frauds? Is it opportunistic, for instance? What's the route to market? So by opportunistic, what we mean is it an individual who perhaps has had a genuine incident, but has taken the opportunity then to maximise the loss in order to recover as much as they possibly can from the incident. That's very different to what we see in the organised space. This is networks of individuals who deliberately set up claims in order to route them through to the market, in order to obviously receive that alleged compensation. It's that whole money-making scheme. And I talked about one of the first fraud rings I dealt with, but that was organised in nature. So we had a number of individuals who were employees for a well-known telecommunications company, and they essentially had been targeted by a claims farmer, or I should say a professional enabler, as we'd call them now, because he ran his own claims management company at the time. And they were targeted in the local McDonald's, and following that there was multiple fictitious claims that were presented. In the end, we broke the network, and 27 individuals were convicted of conspiracy to defraud, all employees of that particular telecommunications company. So that's what we mean by organised. Enabler-led, this is something which has definitely been more prolific over the last 5 years. It can be professional, or it might not be professional. So the industry initially started to call enabler-led professional enablers, so medical experts or engineers, anybody really dare I say it, lawyers, solicitors, those that had the professional title. But as things have moved on, we look at enabler-led as individuals who are effectively enabling the fraud to take place. A very good example of this is we saw a lot of migrating fraud into the property arena. And about 2 years ago, cavity wall insulation claims were the newest thing. And that was absolutely enabler-led, because it was led by the engineers and those companies that had been working in the cavity wall insulation space. So it very much depends on who's routing the claims into the system. And finally, farming, the supply chain. So you may have seen reference to this regularly in the media, but to bring this to life a little bit, back in 2017, the holiday industry, tour operators, insurers had a really difficult problem on their hands with increasing incidents of claims being presented, particularly in the holiday sickness space. And in fact, it was up by 500% in terms of the new claims being entered into the system. What actually the fraudsters had identified was that to go on an all-inclusive holiday and then to become sick was quite an easy legal argument to have from a liability perspective. So what they were doing was they were using reps, not reps from the holiday company, I should say, but they were recruiting reps, putting them outside of hotels to sign up individuals coming out of the hotels, basically saying, look, if you've been a little bit ill or if you don't like the quality of the hotel, we can get some compensation for you. So not even telling them actually the legal truth of the claim. And that was massive from a farming perspective. We saw a lot of that. And we also see it a lot in terms of late notified claims where farming activity is what's routing the claims into the system. Okay, thanks, Gareth. Next slide. Okay, so in terms of what you're looking at from a day-to-day perspective and what we look at, it's understanding for us the red flags or triggers, and I'll come on shortly to the ways in which the strategies we adopt to identify and detect fraudulent activity. But from a sort of red flags triggers point of view, it's definitely worth looking at it from an opportunistic point of view versus what we would look at from an organised, farmed or enabler point of view. So from an opportunistic point of view, you'd be looking at the individual's claim, inconsistencies within the statements or the medical evidence or the invoices, the incident time and dates, incident versus reported losses, what the claims history looks like, medical records, and it's building up that picture of actually, are all these losses genuine, or is this individual exaggerating the losses, or did the incident occur in the first place? Financial motivation is usually key in certain areas. We saw that being quite prolific within the property arena, and also grievances. So we look at that from an employer point of view as well, an employee. That's different to what we look at when we're considering organised, farmed or enabler claims. So in terms of spotting that, you really want to be looking at who's involved in the claim. So which companies are involved? Are they known protagonists? Are there similar features? So do you have a spate of claims with, I'll give you an example because it's something I'm looking at and is very relevant to me right now, a spate of storage invoices, all emanating from a community, all of which happen to be 28 days. It's very, very bizarre, given that everybody's circumstances are slightly different. We look at, you can look at the credit hire organisations, the CMCs, we've also had recently a spate of citizens advice style organisations who are giving general community advice, but then also rooting in fabricated claims. So it's looking at who's involved in the actual claim itself, who sits behind the claim, and what the triggers are within that claim to give you that information in order for you to focus your investigations further on that claim. Okay, Gareth, if you could move on. Okay. So what strategies do we adopt to detect fraudulent activity? Well, we detect fraudulent activity through 4 key areas. The first being intelligence and data. So we have quite a sophisticated intelligence system called Sentry. Now, every time a new claim comes into the Clyde Co casualty environment, that is automatically screened against our fraud data, which sits within a contained environment within our Sentry system, and it looks for matches. So it will look for matching pairs, so it will look for the claimant, it will look for vehicle details, it will look for everything from mobile telephone numbers to the organisations that were involved in the claim to see whether actually we have a match on that and we've investigated either the company or the individual previously. And what I should say is that's really important in terms of looking at that across insurance product lines, because we know our fraudsters move around. So a really good example of this is we had a serial claimant who was presenting a claim, an EL claim, a claim at work. He was also targeting a motor insurer. He had a motor claim, and he was also targeting a corporate for a claim that was completely off the radar in terms of his claims history. There was all sorts of activity going on. So actually playing matching pairs to spot those kind of fraudsters is really important, and data really is key to that, and washing those claims. And now all of your organisations will have different ways of identifying and detecting fraud, but these are the ways in which we at Clyde Co detect incoming fraud. So if we can move on, KYO, this is know your opponent, absolutely critical where you're looking at certain organisations, certain law firms. I would happily share with you some of those that are on our hit list currently, but I think we might have to do that on an individual basis. So if there are any that you have some concerns about, please feel free after this session to give me a call to have a chat about that. But we do look at organisations, we look at their behaviours, we look at the strategies that they're adopting and the challenges that they are posing, and then we set a strategy based on what we know they will do in terms of the investigation strategy. Okay, thanks, Gareth. The triggers we've talked about, these are very manually based, but they tie into that bigger sort of intel and data and systems piece. And you can't, I've been doing this for a long time now, and you really can't take away that gut feel about a case in terms of things not being right. And actually all of those triggers might not be there at the start of the case. So that also goes to show how important it is to continuously review the papers, particularly in the exaggerated type cases. Okay, thanks, Gareth. And then finally, systems. So I've talked about intelligence and data and playing matching pairs where we can wash our cases against our known intelligence and our known fraud data. We're also pioneering in terms of fraud systems at the moment. We have a fantastic OCR reader, an optical reader, which basically can pull data from documents and again play matching pairs. So it's something else that really is in the armoury in terms of spotting and identifying those inconsistencies at an early stage in order to identify cases to investigate. Okay, thanks, Gareth. So you've spotted a case, what next? I think it's really important to say that, and the reason I started with fraud type and who is controlling the claim is because that really will, once you've spotted it, dictate how you target your investigations in order to achieve the evidence that you want to either repudiate the claim, knock it out, or alternatively to take proactive steps. And those proactive steps could be anything from issuing tort of deceit proceedings or prosecuting the individual. So I've put these types of investigations really into 3 pillars. The first one is what we would do from a sort of intelligence desktop perspective. So looking at everything from social media and open source information. A very good example of this During the holiday sickness period, when we were looking at all the holiday sickness claims, a particular claim came into me and the individual had said, I couldn't move from my hotel room, I was so sick, and I was stuck in bed for a period of 3 days. When we looked on social media, we were able to identify the individual on a holiday in Mallorca, having a very good time in one of the well-known nightclubs. In fact, having such a good time that they were swinging around a pole, having a particularly fun time, drinking and laughing, when in fact they were supposed to be in their bedrooms being sick. So it just goes to show the power of social media on occasion. So it's really important we always look at the subject and we always look at profiling, and look at the consistency around what they say, the incident, what's occurred in the incident and what they can or can't do as a result of the incident, and actually what they can do in reality. We always look at the claims history and the queue matches. Particularly important, we see a lot of claims history activity in those fraud rings, those fraud networks. And quite frequently can build up the evidence in relation to the actual case itself and the individual in terms of the similar fact and linking the case back to fraud rings. We undertake residency checks. That's particularly important at the moment. We have a lot of activity in certain communities where we don't think that the claimants are still residents in the UK, even though proceedings are being issued by their chosen law firm. So we investigate that regularly. We've talked about KYO, and KYO is important, and not just from the perspective of the law firm that's managing the claim on behalf of the claimant, but also knowing who else is in the claimant supply chain, as I call it. Again, data matching, understanding what those inconsistencies look like to really draw out those inconsistencies and then build up a version of events that simply cannot be true based on all the inconsistencies. We also look at the companies involved, the individuals that are bringing the claim and how they're bringing the claim to see how basically the cases are routed into the system. And we always check ID. The middle pillar, those types of investigations are more documentary investigations. Some of these you will do anyway as part of your case handling process. I just wanted to touch briefly on expert reports, because when our fraudsters did migrate, when the holiday sickness space closed down and they migrated over to cavity wall installation claims, the way in which these cases were being routed were through the expert reports. So it's always worth looking at whether you're getting similar expert reports. And we did have a case involving a medical expert who was producing boilerplate templated medical reports, despite the characteristics of the claim or the individual who was bringing the injury claim. So we were able to bring a really good test case and have that particular medical expert struck off, which was fantastic. Which, you know, it's about how you can then tackle the behaviour that's in front of you. We always look at invoices, and again, this depends on the fraud type that you're dealing with, but I referred earlier to those fabricated losses. Generally, we see doctored invoices to support those fabricated losses. Medical records for inconsistencies, personal OH records as well, again for inconsistencies. We always look at the CNF and the pleadings at the point of litigation and how that compares to what, you know, comes in at that claims handling stage and what the inconsistencies look like. In terms of documents, I mean, if you can get footage, video footage, whether it be CCTV, ANPR, a dash cam, whatever video footage. In fact, I had one yesterday I was looking at where we've got doorbell footage, which is just fantastic, because I've now just proven my theory, and we can reject that case immediately based on the doorbell footage. So it's looking for those pieces of evidence that can really help you get to the point of repudiation quickly. And then obviously witness evidence is key. We do a lot of work at the claims handling stage where we we have these cases in at that stage to build the witness evidence and ask the right questions. So some of the tools that that I mentioned here, like Part 18 questions, Part 35, they're more for litigation, but it doesn't stop you from asking those questions. And in fact, I'd advocate that, because the more you ask and the more they refuse to respond, gives you that opportunity to say, well, if this, you know, if the claimant's got nothing to hide, why isn't the claimant answering these questions? We also, dependent on the fraud type, look at things like handwriting verification, and also gathering up previous claims documentation to support overall the evidence for the case that you're trying to prove as being fraudulent. Okay, thanks, Gareth. If we could move on. So I've talked about strategic case handling. I know, for instance, if there is a particular law firm who is prolific at the moment in the industry, I would adopt a particular tactic in terms of dealing with the set of cases that are coming in, because I know that, for instance, they will always present a medical report which is templated. They generally don't have instructions from their clients, the claimant. So I will target strategy to ask those questions. A good example of this is if you are seeing late notified claims from a particular law firm, so you can say, right, do they have instructions? Why are they so late in coming through? And you can start to ask the right questions. That feeds into data, really, because to know your opponent, you need to gather those behaviours, gather that data, understand what you're seeing on a wider basis. So it's really important, not just gather the data, but also sharing internally what you're seeing in terms of behaviour and capturing those. And then once you know that, you can hone in on you can really define your tactics in terms of the cases that you're looking at and the fraud types. And all of that, of course, is to build your evidence package to get to the point where you have enough information to repudiate the claim or consider alternative legal routes. In terms of repudiations, when you get to that stage, what I would say is think carefully about how you position those repudiations. For those really strong cases, you may want to go in quite strongly with your repudiation, but think about that in terms of if you've got any other objectives in relation to the case, because what I wouldn't suggest you do, for instance, is if you've got a really good case and you really want to send a deterrent message, and to do that you want to think about prosecuting the individual, you wouldn't want to necessarily put all your evidence in the repudiation to tip them off. So there are ways and means in which to deal with the case, but it very much depends on what that evidence looks like. And hopefully when I work through a couple of examples at the end of this session, it will just bring that to life for you. Okay, if we can move on, please, Gareth. Could you press it again, please, Gareth, just to see if it... That's better, thank you. No, back one, please. That's it. Lovely, thank you. So some of the things that when we work with clients at the pre-litigation claims handling stage, some of the challenges that they get on a day in, day out basis are here in these three component parts. Refusal of information, and really it's refusal of information is all about building up your case. If a claimant is refusing to give you that information, or a law firm are refusing to provide that information, the best thing that you can do at the pre-litigation claims handling stage is build that picture up in terms of conduct, challenge them, place them on notice that without the information the claim can't be validated, because ultimately the whole point of all of this is to either validate the claim or repudiate the claim. And they, you know, if they are legitimate, they will want you to validate the claim quickly as well, because ultimately they'll want settlement quickly. So definitely challenge. Don't be afraid to challenge, and don't be afraid either to say that you know, we will draw adverse inference if the information isn't given, because all the information is doing is preventing a validation of the claim. The other thing that we get regularly is refusal of documentation. Now, it very much depends on what's being refused. You can, again, suggest that you can't validate the claim without the documentation. If you have a particular concern, you could think about a pre-action disclosure application. A good example of this is we had a spate of fabricated invoice claims, and the claimants had no idea that these claims had been presented. So we wanted to get to the bottom of who the controlling mind was of the claims. That the law firm said to us, it's nothing to do with us. We were just handed this by the referral agency. So we issued a PAD application in contemplation of a tort of deceit action against the law firms, the claimants, and the claims management company, which you can imagine went down a storm with the particular law firm involved, which again, if anybody is interested, I will share that with you after this session if you want to know on a one-to-one basis. But that application was really successful, and we had all of the papers within the claims disclosed to us as a result of that. And then finally, the threat of litigation. Again, if you're going to repudiate, make sure that you position the repudiation which is akin to your objectives. You can repudiate the claim at any point as long as you've got sufficient grounds to repudiate it. You don't have to necessarily have all the evidence, but you would want sufficient amount of evidence or concerns to repudiate and discourage proceedings. And you might also want to consider if it's a genuine incident, or I should say there are genuine losses, you might want to consider making some offers just to protect yourself on that. But again, that's why it goes back to your strategy has to align with what the fraud type looks like. Okay. Could we move on, please, Gareth? And again, please. Sorry, Gareth, it's not moving yet. There we go. Got it. Okay, so just to bring it to life for you, these are 3 case studies, 3 claims that my team and I managed at the pre-litigation stage. The first one is a bike claim, and it's very much part of a wider industry fraud scam. So this particular claim was referred to us not actually because it had been identified by the client as being part of a wider fraud scam, but because there were some concerns because the defendant driver had indicated that they didn't think that the individual that was bringing the claim had sustained any losses because there was no damage to the bike at the scene and there was no reference to any injury. The circumstance to this case was our defendant driver was pulling out of a side road, bike proceeding along the main road, and they briefly touched. The bike was considered by the defendant driver at the scene, photographs were taken, didn't look to have any damage from the incident itself. Unfortunately for the driver of the motorbike, the other defendant, or I should say the defendant driver of the other vehicle, not only took pictures of the bike, but he also took pictures of the driver. That wasn't known at the time that came into us, but when we started to investigate, we took a witness statement and we asked for everything that the defendant driver had. When we got the photo back, we were a little bit confused because whilst the individual had a helmet on, so to a certain extent, the individual's face was slightly covered, the claim that had been presented was from a female rider. When we looked at the photographs and then we searched social media, the female rider looked nothing like the individual that was on the bike. And in fact, it looked like her boyfriend. And it definitely wasn't her. So we have repudiated that, but not on that basis at the moment. And the reason being is that we have enough evidence to prosecute the individual. And that the reason we're going down that route is because we really want to understand how that claim was routed into the system. So it's part of a much bigger operation where we know courier drivers are targeting commercial vehicles in order to bring fabricated claims. And would you believe it? The bike was written off as a result of the incident, despite having no damage. So that's just an example of how you can build up the evidence and then look at the strategy in order to deal with the claim, but also looking at what is your overall objective for that claim. The second case study, the slipster claim. This was an individual claim that came into us. It was an EL claim. So the claimant alleged she had walked into the female lockers and the cleaners had left a pool of water hazardously, and she had walked in and slipped on this pool of water. When we got the CCTV footage, it was one of those moments where you have to smile, actually, because not only did the CCTV footage not show any water on the floor at all, but the claimant had obviously been told how to try and fake the slip. So you could see her pretend to trip over something, even though she didn't, and then try and put a hand out and try and hold on to one of the lockers to straighten herself up, which was really quite funny from a CCTV point of view. But in all seriousness, not funny from a obviously fraudulent claim perspective. That claim was repudiated, and what we actually took I talked about earlier, the citizens' advice, or the company that had routed her claim into the system, we actually took them to task and reported them to the regulator, and they were closed down. And then finally, something which is very, very close to my heart, because I sat in court on a number of days on this case, and it was quite not only an interesting case, but in some respects, in many respects, quite a sad case. So this is a holiday sickness case. I talked earlier about our fraudsters migrate and move around, and they will look for any opportunity, any area to bring as many claims as they can. Back in 2017, because of the way in which the legal environment was, strict liability claims were the flavour of the day for our fraudsters in relation to holiday sickness. We had this claim in at pre-litigation stage because our client was experiencing an unprecedented volume of these claims coming through. And so we worked with the client to put in place a new fraud identification system and an early targeting of the claims in order to build up the evidence. They sent this particular one through, and immediately when we started to investigate, I knew it was the case that we could use in order to set not just a precedent, but a deterrence for the industry. Deborah and Paul, couple with 2 children, been on holiday to the same hotel in Mallorca for several years. Was so well known to the reps, the hotel owners and the individuals that worked at the hotel, that they were all on a WhatsApp group. They were all familiar with each other. They shared social media. They'd been to this hotel for a number of years. Then in 2017, a number of claims were submitted for holiday sickness, for injury, by Deborah and Paul, and for their 2 children. And they submitted claims not only for the previous holiday year, but for the holiday year before that as well. So in essence, 8 claims for injury. When we got the claim, we contacted the hotel, and the hotel had, when the claim had come through to them, or they'd been notified that these claims were being made, one of the hotel reps had messaged Deborah to say, Deborah, I don't really understand why these claims have come through. We thought you really liked our hotel and always had a really nice time here. We don't understand it. Deborah, in a moment of stupidity or weakness, whatever you want to call it, messaged back and said, I'm really sorry. It's Paul and his dodgy mates in the pub. That was it. That was done. It was a done deal at that point for me, because we had enough evidence in order to consider what further steps we could take. And at that point, we pulled in all the evidence, made sure we had the medical reports where they'd been to see medical experts to say they'd suffered holiday sickness, pulled in all of the documentation from the hotel, and we launched a private criminal prosecution on behalf of the client. And we laid the information in front of the magistrates. The magistrates issued a summons, summoning Paul and Deborah to the magistrates. They turned up for the first hearing and pleaded not guilty. So the case was transferred to the Crown Court. We prosecuted under the Fraud Act. So we privately prosecuted for the company. So we sat in the shoes effectively of the Crown. It went to Crown Court and they initially pleaded not guilty. And then in between time, I was able to get an order for disclosure of all their documentation that was held by the claimant law firm in terms of their claim. We then got a call. We got a call to say they're going to plead guilty. And Gareth, if you could move on, this is what happened next. So, following pleading guilty, the judge took a deterrence strategy and he basically committed both Deborah and Paul to prison immediately, custodial sentence. And I've got it here, and I do have to read this because I think it shows what can happen if you build the right case. This was the judge, David Aubrey, QC. Those who may be tempted in the future to make a dishonest claim in relation to fake holiday sickness, if they are investigated and brought to justice, whatever the circumstances of the individual, he or she must expect to receive an immediate custodial sentence. Deborah got 9 months and Paul got 15 months. And actually, the sad thing about it, well, whilst they knew these were fake claims, would they have been persuaded to bring those claims in it if they hadn't met the dodgy man down the pub? And there were 2 children here as well. So they had to go into care during that period. So quite upsetting, I think, in terms of the family, but clearly fraud doesn't pay, and that's the deterrence message that needs to go out. So I suppose just wrapping that all up, I then found myself telling the story to the nation, if you could move on, please. Yeah, on claims and shames. My family think this is hilarious. I'm the star of the family because I've actually been on BBC, but I'm not the star of the family, honestly. So just the importance of it, really. If you get it right at that claims handling stage, what really can occur as a result of that, and ultimately protecting your organisations from fraudulent activity. So I hope that really does bring out and help you understand and describe the strategies to detect fraud, how you can spot it, the types of strategies you can use, some of the intelligence and investigative strategies that can be used, and also what really can happen once you've built that evidence package. And I think we're moving to the Q&A.
Perfect. Thanks, Sarah. Fascinating insight into the world of fraud there. So, yeah, any questions please feel free to use the chat facility on Zoom. At the moment, I just have one question while I'm waiting for others to come through. So do type those in now. So what, Sarah, are some of the emerging threats you are seeing in relation to claims fraud?
Well, Tim, one of the things, so I've talked about, we have seen migration of fraud claims into across insurance product lines, actually. So historically, you know, when I started out, motor was the place to be, but we have seen fraudsters now in all areas, from property, travel, pet. Would you believe it? We've seen a number of what we would call professional enabler cases coming through. So nurses, fabricated invoices. So I suppose because there's always going to be an evolution and migration of fraud, the emerging trends really do hone in on what the legal environment looks like. And one big area that we're seeing as emerging at the moment is this whole piece around vulnerability. We've just had a new cost regime come into play, extending fixed recoverable costs into the 25 to £100,000 bracket. And vulnerability is key in terms of where you are in that bracket or whether you can drop out. So we're already seeing claimant law firms advertising for claimants who have vulnerabilities. So if anybody wants any more information on that, I would say that is the most prolific area to concentrate on at the moment in terms of emerging threat.
Great, thank you, Sarah. Have no other questions coming through at the moment. So on that note, I think we'll close the session. So thank you very much, Sarah, for your time. That's much appreciated. Fascinating, as I say. And thanks also to all of you for joining us. Please don't forget to provide your feedback and do look out for forthcoming MGAA events. You can see Sarah's contact details on the slides there, or if you wish, feel free to contact me at tim.richards@mgaa.co.uk. I'm just looking to see if any questions have come through. I think there is one, actually. When you mention prosecuting the individuals, is this in reference to the IFED involvement? If IFED decides not to accept a case, as from my understanding they turn down more than they accept due to volume, what route is available to seek prosecution, if any?
So there is the IFED route, but in the case that I talked about in terms of Britton and Roberts, we privately prosecuted. So there is room within the law for a company, an organisation to criminally prosecute themselves. And privately, whilst you're still part of, or you become the prosecutor, so rather it being the Crown prosecution, you are the prosecutor, you are still subject to the same rules. So what's really beneficial in relation to that, as long as you've got the right case, the right evidence, is that win or lose, you still recover your costs from central funds. So there is the opportunity there for you to privately criminally prosecute. You don't have to go through IFED or indeed the police. The other legal tools available, you can bring an action in the tort of deceit and also bring an action for exemplary damages where you're looking to recover from the fraudster and also receive damages from the fraudster for their activity. So that's another route. So there are routes available. It doesn't necessarily just have to be through industry body.
Great, thank you, Sarah. And one message from Richard Cliff, which is really to us in the MGAA, really. Will the deck be available? I can answer that one, and the answer is yes. So look out. Anyone that's registered will get a copy of the slide deck and a link to the recording of the session. So thanks again, Sarah, and thanks everyone else for joining us, and I hope you all have a productive day. Thanks again.
It's brilliant. Thank you.
Thank you. Bye-bye.